crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, timeline and justification of the appeal. David Schwartz, Ripple Labs Chief Technology Officer, recently discussed the latest development in the company's legal battle with the United States Securities and Exchange Commission. A post on X previously Twitter. A post on X previously Twitter. Schwartz's observations are timely in that they provide light on the SEC's reasoning for its recent appeal. Schwartz summarizes the SEC's approach, which centers on the Commission's belief that the litigation has not yet come to a conclusion. This view implies that parties have discretion to file appeals after the completion of the case. The primary goal of this strategy is to streamline the judicial system by preventing the main proceedings from being constantly sidetracked by several appeals on subsidiary rulings. The appeal arose following the crucial ruling by Judge Annalisa Torres on July 13 that XRP is not a security, even when traded on cryptocurrency exchanges. Although the judge ruled in favor of Ripple, the SEC is appealing on the basis of a new legal theory. The problem of parallel proceedings. Schwartz stresses the need of merging appeals and argues that separate appeals might extend the judicial process unduly. However, the current situation presents a complex obstacle. The SEC's position is that this case presents unusual circumstances that call for a departure from the norm. They want to halt the main case until the appeal is heard and decided. Ripple's conviction, though, is unshakable. Until an appeal, the principal case should continue. This approach is consistent with the judicial predilection for moving the main trial forward and dealing with appeals as a whole once the major case has been resolved. In addition to these procedural nuances, Schwartz also felt it was important to clarify rumors that were circulating within the Bitcoin community. There were rumblings that the SEC would appeal Judge Torres' judgment to a higher court. The outcome of the courtroom drama hinges on whether or not the appeal will be admissible, which may significantly alter the trajectory of Ripple Labs' case with the SEC. Surprisingly, the U.S. Securities and Exchange Commission, SEC, has asked a federal court to let top SEC attorney Pascal Guerrier to withdraw from the litigation against Ripple and XRP. Since then, the senior lawyer has formally withdrew from the case, throwing the legal processes into more doubt. The SEC's legal campaign against Ripple included important contributions from notable figure Pascal Guerrier, who is well known for her expertise in securities law. There has been much conjecture as to the cause of her abrupt departure since no explanation has been given. First, Guerrier's departure may indicate that the SEC is split on how to go forward with its investigation into Ripple and XRP. Given her high rank at the agency, her resignation may indicate underlying problems with the SEC's approach to the case. Second, the judicial system may experience delays as a result of this new information. When changing lawyers, there's often a period of time spent as the new group learns the ropes of the case, which might slow things down. Finally, some in the cryptocurrency industry see this as good news for Ripple and XRP. There's been conjecture that the SEC is having trouble proving its case against the digital asset, despite the fact that it is impossible to forecast legal results based only on changes in legal teams. Finally, the SEC's decision to dismiss Pascal Guerrier from the Ripple complaint introduces a new and intriguing dynamic into an already contentious and highly followed judicial struggle. As the case progresses, everyone will be watching to see how this change affects Ripple and the future of XRP. And SEC disclosure was made public thanks to the tweeting of Fox Business reporter Eleanor Terrett. The Commission has notified the judges of the acceptable and unacceptable court appearance dates for the second quarter of 2024. Ripple's CEO Brad Garlinghouse and co-founder Chris Larson's legal representation have notified the presiding judge that their clients would be unavailable from April 1 to April 14, 2024. Since that time, the trial for the legal issue has been pushed out until April 2024. The SEC and Ripple Labs have agreed to begin formal litigation in the second quarter of 2024. The SEC has detailed particular conditions for participation, despite the fact that the corporation is given a flexible schedule and offered to engage in proceedings at any moment during the term. Both Ripple and the SEC have confirmed in formal letters to U.S. District Court for the Southern District of New York Judge Annalisa Torres that they expect to go through with the appeals in the second quarter of 2024. This latest correspondence was prompted by a court order granting an interlocutory appeal to the SEC in the continuing lawsuit against Ripple on August 17. This followed the verdict from July 13 that gave each side some success in the case. It has been claimed that the absence of Ripple's top executives coincides with the expected Bitcoin halving, a major event in the cryptocurrency market. On or around these dates, the Bitcoin network's mining incentives will decrease. Challenges with regulators have been a major stumbling point for Ripple and its digital currency XRP. John Deaton, an authority in cryptocurrency litigation, explains how the U.S. Securities and Exchange Commission (SEC) has stymied XRP's development. An advocate for XRP, attorney John Deaton, recently turned to Twitter to voice his displeasure with the cryptocurrency's performance after the implementation of the Ripple V's Securities and Exchange Commission secured litigation. Following its recent investment in Circle, a significant USDC stablecoin on its platform, Coinbase has released a statement explaining that it spoke with SEC lawyers before deciding to list XRP. Without the SEC case, Deaton says Coinbase could have gone with Ripple instead of Circle. It's interesting to compare the transaction times of Coinbase's XRP and Circle's USDC, which were both published around the same time. The process of getting XRP back on Coinbase was more involved than just another purchase. Due diligence was required, and it was carried out with great care to guarantee that all rules and regulations were followed to the letter. To successfully traverse the regulatory environment, Coinbase took preventative precautions by communicating with the U.S. Securities and Exchange Commission (SEC). This interaction was essential in establishing the legitimacy of XRP as a digital asset rather than a security. There was a meeting between the SEC and Coinbase to talk about how to categorize XRP. Coinbase and the SEC had a conversation on XRP, and interestingly, the SEC did not raise any objections. John Deaton, the CEO of Coinbase, released a statement in which he expressed optimism about the company's regulatory harmony in light of its plans for an initial public offering. Deaton has seen that Coinbase has been actively promoting XRP and another stablecoin, USDC, during the last several months. When compared to the time and effort required for conventional bank wire transfers, digital assets were seen as revolutionary by the exchange. An unexpected turn of events occurred during the intensive advertising campaign. Former SEC Chairman Jay Clayton's lawsuit against Ripple, which alleged that XRP was being traded illegally as a security, sent shockwaves across the cryptocurrency market. Despite the SEC's prior statements to the contrary, a complaint was filed challenging whether or not XRP should be considered a security. The SEC allowed MoneyGram International Inc.'s use of XRP in its international payment system 18 months ago, but that didn't stop the new legal action. The SEC allowed MoneyGram International Inc.'s use of XRP in its international payment system 18 months ago, but that didn't stop the new legal action. Deaton stresses the negative effect of legal disputes on XRP's future development. These obstacles have stopped us from taking full advantage of our situation and have cost us valuable time and resources.